Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGuinness Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. Just in the past week, both Australia and the UK have taken what I think are massive steps to harm the free and open internet. And there's a serious chance this could be coming to Canada too. Now, you may have seen some coverage or even gotten notices from the services that you use that some users will have to verify their ages to get access to certain services or features. But it's really about more than just age verification. According to the BBC, Reddit users who want to access subreddits that are tagged as not safe for work will have to connect to an outside firm that will perform age verification for them, either through an uploaded selfie or an image of your government ID, such as a passport. Reddit says they will not have access to the photo, and their contractor will only retain a user's verification status and date of birth, so people don't have to re-enter it each time they try to access restricted content. Now, to me, this is a problem. Adults and children have a charter-protected right to access information, and there's also a charter-protected right to anonymity. Like other charter-protected rights, these can be subject to reasonable limitations prescribed by law that can be demonstrably justified in a free and democratic society. Now, there's a bill again working its way through the Canadian Parliament that presents a clear and present danger to the free and open internet, at least in Canada. A danger to freedom of expression and to privacy online. It's a private member's bill that shockingly almost made it into law during the last Parliament. Last time, it was called Bill S-210, with a short title of Protecting Young Persons from Exposure to Pornography Act. Now, it has been reintroduced with some small but important changes in the current Parliament as Bill S-209, with the same short title, Protecting Young Persons from Exposure to Pornography Act. In a nutshell, it will require any website on the entire global internet that makes pornographic material available to people in Canada to verify the age of anyone who wants access, to ensure that they're not under the age of 18. Now, keeping pornographic material away from kids sounds like a laudable goal, and one that most people can get behind. But the devil, as they say, is in the details. As I said, this presents a real risk to privacy, a real risk to freedom of expression, and a real danger to the open internet in Canada. The author of the bill says it does none of that, but I believe she's significantly mistaken. The original Bill S-210 was introduced in the Senate of Canada in November 2021 by Senator Julie Miville-Deschênes. She's an independent senator who spent much of her career as a journalist, which makes her complete obliviousness to the freedom of expression impact of her bill really puzzling to me. I don't think she's acting in bad faith, but I think she's significantly mistaken about the scope and the effect of her bill. Now, to the amazement of many, the previous Bill S-210 made its way through the Senate, made it most of the way through the House of Commons, and was voted to be referred to committee. Every Conservative, Bloc Québécois, and NDP member present voted in favor of this referral to committee, while most Liberals were against it. Suddenly, the bill had traction and what appeared to be broad support among the opposition parties. Thankfully, the bill died when Parliament was prorogued, and the new Bill S-209 will have to go through that process again, but it may be fast-tracked. So what does the bill do and why is it problematic? Let's go through it clause by clause, and I'll also highlight what has changed since Bill S-210. The main part of it, the prohibition and the offense, is contained in Section 5. It creates an offense of making available pornographic material on the internet to a young person. This incorporates some pretty important defined terms from Section 2. Making available is incredibly broad. When a definition says includes, it means that it can mean more than the terms that follow. Transmitting is a very, very broad term. Is that intended to cover the people who operate the facilities over which porn is transmitted? Again, that is itself very broad. A young person is defined as a person under the age of 18. Now that's pretty clear. You'll notice that I've crossed out sexually explicit material. That's because in the new Bill S-209, the bill no longer uses the definition of sexually explicit material from the criminal code. That definition is in the code for a particular purpose, to make it a crime to provide certain material to a young person to facilitate another offense against a young person, essentially grooming a young person. The new bill uses a new term with a new definition, pornographic material. And it says pornographic material means any photographic, film, video, or other visual representation, whether or not it was made by electronic or mechanical means, the dominant characteristic of which is the depiction for a sexual purpose of a person's genital organs or anal region, or if the person is female, her breasts, but does not include child pornography as defined in subsection 163.1 sub 1 of the Criminal Code. Let's take a moment and let that sink in. This is not limited to porn sites. It's simple nudity for a sexual purpose. This sort of material is broadcast on cable television. It's certainly available in adult bookstores, which specialize in certain types of publications, but it's also available in general bookstores. This sort of material is available in every large library in Canada. And this definition would include educational materials. This definition is so broad that it covers Wikipedia articles related to art, reproduction, and sexual health. And back in the pre-internet days, the Sears catalog was used for a sexual purpose. This definition, which is at the core of this scheme, is certainly not limited to materials that would cause a reasoned risk of harm to a young person. And it doesn't take any account of the different maturity levels of young people. The sex ed curriculum is very different for 14-year-olds, 16-year-olds, or 18-year-olds. But if it's nudity, and the purpose can be seen as sexual, then it's within the definition of pornographic material in this bill. You'll also note that it says for commercial purposes. This is really vague. The new Bill S-209 does add a clarifying section, however, at Section 6. And it says, for greater certainty, for the purpose of Section 5, an organization that incidentally and not deliberately provides a service that is used to search for, transmit, download, store, or access content on the internet that is alleged to constitute pornographic material does not make available pornographic material on the internet for commercial purposes. I think this is a good addition. It should exclude general search engines. And because making available is such a broad term and it includes transmitting, the old Bill S-210 would have scoped in internet service providers and web hosting companies. It would have included services like Dropbox and iPhoto. Now, Section 7, which was formerly Section 6, is where the government-mandated age verification technology comes in. Essentially, you can't say that you thought you were only providing access to the defined material to adults. You have to implement a government-prescribed age verification method or age estimation method to ensure that the people getting access are not under 18. That's essentially the only due diligence defense. The new Bill S-209 also includes something called age estimation, and we'll talk about government-prescribed age verification and age estimation methods shortly. Now, there is another defense, which is legitimate purpose. No organization shall be convicted of an offense under Section 5 if the act that is alleged to constitute the offense has a legitimate purpose related to science, medicine, education, or the arts. Maybe that will be interpreted broadly so that Wikipedia articles related to art, reproduction, and sexual health are not included. But it's a defense, so it has to be raised after the person is charged. The onus is on the accused to raise it, not on the prosecution to take it into account at the time of laying a charge. We'll talk about blocking orders in a minute, but because this is a defense to a charge, it does not come into play if the regulator seeks to have the site removed from the Canadian internet. There's also a defense that's available if the organization gets a Section 9 notice and complies with it. What the heck are those, you might ask? Well, the bill has an enforcement authority who I'm afraid will be the CRTC. If they have reasonable grounds to believe that an organization committed an offense under Section 5 by allowing young people to access pornographic materials, the enforcement authority may issue a notice to them under this section. And the notice names the organization, tells them they have reasonable grounds to believe that they're violating the act, but they don't have to provide the evidence of this. And they essentially get to order the organization to take, quote, steps that the enforcement authority considers necessary to ensure compliance with this act. It doesn't say that are necessary, but what the enforcement authority thinks is necessary. So the organization has 20 days to do all the things specified in the notice. They do get to make representations to the enforcement authority, but that doesn't stop the clock. The 20 days keeps ticking along. And you know what's deranged about this? The order can be issued solely on the basis that the enforcement authority has reasonable grounds to believe an offense has been committed. They don't even need to sincerely believe that an offense has been committed. And they don't actually have to prove that an offense has been committed. There's no independent adjudication of whether a violation actually takes place. And here's where the rubber then hits the road. The enforcement authority, if they're not satisfied that the organization has taken the steps that the enforcement authority deems to be necessary, the enforcement authority gets to go to the federal court to get an order essentially blocking the site. Specifically, it says, for an order requiring internet service providers to prevent access to the pornographic material to young persons on the internet in Canada. Now, any internet service provider who would be subject to the order would be named as a respondent to the proceedings, and they presumably can make submissions. But I can only think of one or two internet service providers who would do anything other than simply consent to the order, some of them privately cheering because it's another precedent for content blocking. Now, take a look at this section, which sets the criteria for the issuance of an order. It says the court must issue the order, not may, but they must, if there are reasonable grounds to believe that the organization committed the offense under the Act. It doesn't require proof beyond a reasonable doubt. It doesn't even require proof to a civil standard, like the balance of probabilities are more likely than not. And it doesn't even require actual belief based on evidence that an offense was committed. It requires only reasonable grounds to believe. And it requires them to not have taken all the steps dictated by the enforcement authority within the extremely brief period of 20 days. Finally, the order must issue if the court determines, quote, the services provided by the internet service providers who would be subject to the order may be used in Canada to access the pornographic material made available by that organization. The court doesn't even get the opportunity to consider whether in the totality of the circumstances it is in the public interest to issue the order. If A, B, and C are met, then the court must issue the order. That is a really, really low bar for taking a site off the Canadian internet. But wait, there's more. The Act specifically authorizes wide-ranging orders that would have the effect of blocking material that's not explicit and barring adult Canadians from seeking access to that same explicit material. And if you look at the first sentence of subsection 5, it says, if the federal court determines that it is necessary to ensure that the pornographic material is not available to young persons on the internet in Canada, it doesn't say anything about limiting the continuation of the offense or even tying it to the alleged offense set out in the notice. It also explicitly permits collateral damage by censoring and removing material that's not at all problematic. And remember, all Canadians have a charter-protected right to access lawful material. So as we've seen, all of this hinges on companies verifying the age of users before allowing access to explicit material, and the only substantial defense to the offense set out in the Act is to use a government-dictated and approved age verification or age estimation method. We need to remember adult Canadians have an unquestioned charter-protected right to access just about whatever they want, including sexually explicit material. And they also have a charter-protected right to anonymity. Now, the criteria for approving an age verification method may be the only bright spot in this otherwise dim Act. And it's only somewhat bright. Before prescribing an age verification method, the government has a long list of things that they have to consider. Specifically, the Governing Council must consider whether the method A is highly effective. It used to say reliable in the old Bill S210. B is operated by a third-party organization that deals at arm's length from any organization making pornographic material available on the internet for commercial purposes. This paragraph B is a new addition. Paragraph C maintains user privacy and protects user personal information. D collects and uses personal information solely for age verification or age estimation purposes, except to the extent required by law. E limits the collection of personal information to what is strictly necessary for the age verification or age estimation. F destroys any personal information collected for age verification or age estimation purposes once the verification or estimation is completed. And G generally complies with best practices in the fields of age verification and age estimation, as well as privacy protection. In the old Bill S210, this list was only kind of good to have. Now it says the Governing Council must ensure that the method does these things. But there are a lot of experts out there who have concluded that privacy protective age verification or age estimation really doesn't exist, at least not yet. And there's no obligation on the part of the government to seek input from the Privacy Commissioner on which measures to adopt. And so what's the current state of age verification? It's not uncommon for some websites to require a credit card under the assumption that a person with a valid credit card is likely an adult. I'm not sure that's the case anymore, and it may not be reliable. There's also ID verification, which is often coupled with biometrics. You take a photo of your government-issued ID, take a selfie, and software reads the ID, confirms you're over 18 from the ID, compares the photo on the ID to the photo you've taken. Now, that involves collecting personal information from your ID, which very likely includes way more information than is necessary to simply confirm your age. It involves collecting your image. It involves collecting and using biometrics from your selfie and your ID. And do you really want to provide your detailed personal information that could be readily used for identity theft or fraud to a porn site, or even to a third-party age verification service? One scheme was proposed in the UK a number of years ago in which you would go to a brick-and-mortar establishment like a pub or a post office or a bank. You would show your ID and be given a random-looking code. That code would confirm that someone reliable checked your ID and determined you were of age. Of course, this becomes a persistent identifier that can be used to trace your steps across the internet. And I can imagine a black market in ID codes emerging pretty quickly. And then there's also some other important things we need to think about. For example, is it universally applicable and available? Not everyone has government-issued ID. Some systems rely on having a valid credit card. Not everyone has one, let alone a bank account. The bill's sponsor and supporters say smart people will come up with something that's reliable and protects privacy. Well, why don't we wait until we have that before considering passing a bill like this? It's pretty important to know that if passed, the law doesn't wait to come into effect until there's a designated compliant and approved age verification or age estimation that's available. Let's game this out with a hypothetical. Imagine, if you will, a massive online encyclopedia. It has thousands upon thousands, maybe millions of articles authored by thousands of volunteers. They cover the full range of subjects known to humanity, which of course includes reproduction and sexual health. A very small subset of the content they host and that their volunteers have created would fit into the category of pornographic material. But it's there, it exists, and it's currently not age-gated. The operators of this encyclopedia very reasonably take the view that their mission is educational, non-commercial, and they're entitled to the protection of the legitimate purpose defense that is supposed to protect science, medicine, education, or the arts. They also take the view that in providing access to their educational material in Canada, that it's protected by the Charter of Rights and Freedoms. And they also reasonably take the view that the Charter protects the rights of Canadians to access the content that they make available. But one day, some busybody complains to the CRTC's porn force that this online encyclopedia contains material that may be sexually explicit. The captain of the porn force drafts up a notice under Section 8 telling them that they must make sure that only people who have confirmed their age of majority via government-approved age verification technique can get access to the explicit content. The encyclopedia writes back and says, please let us know what is your criteria for judging whether something is published for a sexual purpose, as required in many parts of the definition. Also, they say their purpose is entirely educational, so they have a legitimate purpose, and they also mention the Charter. But meanwhile, 20 days fly by. So the porn force makes an application in the federal court and serves notice on all the 8 major internet service providers in Canada. None of the internet service providers show up at the hearing. The publishers of the encyclopedia hire a really good Canadian internet lawyer who tells the court that the encyclopedia's purpose is legitimate and related to education. And they're likely not engaged in commercial activity. And cutting off access to the encyclopedia would be unconstitutional as a violation of the Canadian Charter of Rights and Freedoms. The government lawyer, on behalf of the porn force, points to Section 10 sub 4 and says the court has no discretion not to issue the order if there are reasonable grounds to believe an offense has been committed and they didn't follow the dictates set out in the Section 9 notice. Even with the encyclopedia's information about their purposes, the bar of reasonable grounds to believe is so low that paragraph A is met. Since the encyclopedia didn't follow the Section 9 order because they were pretty sure they had a defense to the charge, paragraph B is met. And an order to all Canadian ISPs to block access to the encyclopedia would have the effect set out in paragraph C. Kind of slam dunk. The court must issue that order. But what about the fact that it would have the effect of cutting all Canadians off from the 99.999% of the site's content that's not explicit? Tough. Paragraph 5 of Section 10 says, yeah, that's okay. No encyclopedia for you. A charter challenge would then be raised and the whole thing would likely be declared unconstitutional as a violation of Section 2B of the Charter that can't be justified by Section 1. In short, even if you think this bill is well-intentioned, it is heavy-handed, poorly constructed, doesn't take freedom of expression into account, and imagines that we can manufacture some magical fairy dust technology that will make the obvious privacy issues disappear. In short, it is a blunt instrument that imagines it will fix the problem. And I should also note that it will likely have the effect of hurting older children who haven't yet hit 18. The internet, its many communities and information repositories are all critical for young people seeking legitimate information related to sexual health, sexual orientation, and gender identity. Some of this information would fit into the broad definition of pornographic material, and it will be illegal for someone to allow them access via the internet. It will remain legal for them to get it in a bookstore or a library, but that's not how young people generally access information in 2025. I expect some supporters of this bill will be more than happy to see it limit Canadians' right to access lawful material. Some people, I'm sure, are cheering from the sidelines because it will put up significant barriers inhibiting access to material that the puritanical finger-waggers and pearl-clutchers don't want people to access at all. When the Online Safety Act went into effect in the UK, searches for virtual private networks skyrocketed. In the US, those states with age-based blocks on pornography, people are regularly using technologies and techniques to circumvent those blocks. It's also very important to realize that a person, regardless of age, who is determined to find pornography will seek it out. If the big and legitimate websites implement age verification, there will be thousands of less reputable sites that will not. I'm not aware of any technique that will successfully block sites on the real dark web, so that this completely lawless zone will still be available. And those sites don't respect laws such as those related to child exploitation and non-consensual materials. Now, it's good to see a discussion of this important issue, and we need to revive it as we had for Bill S-210 for the present S-209. And even if you're in favor of the stated objectives of this bill, the bill itself is deeply, deeply problematic. I think it should be parked until there's a way to deal with this issue without potentially violating the privacy rights and charter rights of Canadians. I hope this has been interesting and useful. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. Also leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian tech and privacy law. Thanks for tuning in.